In fact, I might spend the next hour talking to you about how great we are. So I'm Mark. Nice to meet you guys. And of course, what we are. Can you see me? Or do I just sit here? Yeah, it's here. All right. So I'm Mark. It's very nice to meet you guys in person because I've met with many of you by email. I actually am the lawyer of record here, along with a couple of other brokerages. But what that means is that I give the brokerage active support. You guys go to your brokerage, and if the brokerage has a problem, then they usually bring it to me, and then we all make up a solution to pretend we know what we're doing. Life is golden. That's worked pretty well. I think that's been about 2 years now or so working together, and I've really enjoyed it. And in that time, I've gotten to meet a lot of you. What I wanted to point out to you before I begin is that I also run a forum, and I hope that all of you are part of it. I'm part of the Ontario Real Estate Legal Discussion Group on Facebook. We have about 12,000 members now active. And the reason I'm telling you to join is because Ontario Real Estate Legal Discussion Group for professionals. And we have any number of lawyers and realtors who ask legal questions and solicit legal information on that forum. And we also have videos. And strangely, tomorrow, I'm allowing someone on our forum named Brian Madigan, who's pretty esteemed in this area and really knows education, and he's presenting on clauses. So you can actually compare what I'm about to say today to what Brian is going to say tomorrow. We have not compared notes. I'm sure it'll be totally separate. But just letting you know, that type of stuff happens all the time. It's free, and please be welcome to have you guys all join. So I'm talking about something that has been requested of me to speak about for years and years and years, and I've never done it. I've never done it because I always see clauses as kind of simple, straightforward stuff, like we understand what they are. But the more I started thinking about it, the more I realized, there are certain clauses that A, we're not all that familiar with, and B, there's the law of clauses surrounding them and how they actually work into an agreement of purchase and sale. So to that end, we are going to talk clauses today. I always do some little thing at the beginning, mainly for my own amusement, not for yours. Now that we're past that, we can. I can just push that.
Everybody steals the back seats. People that come on time.
Is this? Hold on. Sorry, guys.
You do have a hand up in the online meeting too.
All right. Well, is it working now? No, I'm just trying to. You want to scroll them. I just want to scroll out of the screen back. Oh, it's just okay. All right. Yeah. All right, that's fine. Okay, good. Well, that's easy. All right, so let's talk about the law of clauses. And the law of clauses is not really a law of clauses. There's no law of clauses, but there is a law of contract. And I decided to distill certain principles from the law of contract as it relates to clauses first to begin. We'll get into specific clauses towards the end as well, because I'm sure what you're going to have questions about. But I just want to make sure that you understand how clauses work. So the first thing that you need to understand about clauses is a Latin term. I don't know why lawyers, actually I do know why lawyers speak Latin. You know why lawyers speak Latin? It's because they were trying to make themselves look more important than they are. I mean, we all know lawyers to be very, very, very important people. But in an effort to kind of make ourselves appear more important than we were back in the days of the Guild, and to differentiate us, we used to speak in Latin. And unfortunately, some of the words are still used, including this term contra preferendum. I'm going to start there. You don't need to remember what the Latin is, because believe me, if you start speaking Latin to one another, someone's going to punch you in the face. But contra preferendum is the principle that anything you write supersedes anything that is standard form. This is law. This is the way law is interpreted by the courts. What this means is that anything in Schedule A necessarily supersedes anything in the standard form by common law. And so if there is ever a discrepancy, so for instance, a common discrepancy that you'll often see is someone who says the buyer agrees that there is a tenancy on the main floor and that the seller agrees to assume that. But but they don't cross off section 2 of the agreement, completion, that says vacant possession is to be provided. Technically, you therefore have two conflicting clauses in the agreement of purchase and sale. If someone were to go to court on that and say section 2 says this, but Schedule A says this, there's confusion, it's not clear and definite, a court would say, hell's no, contra preferendum. Clearly, what has been written by the parties was intended to supersede what is there. Does that make sense as a matter of course, just so we understand it? And by the way, I have had a court case where Schedule A has superseded Schedule B. And what I did was I submitted as evidence the fact that Schedule B was a standard form available on MLS for download and wasn't part of the contemplation of the parties, but Schedule A most definitely was, and contra preferendum then took hold there. And Schedule B said chattels and fixtures shall be in as-is condition. Schedule A said chattels and fixtures shall be in good working order. What to do? Well, Schedule B was seen as standard form, though it was less standard form than perhaps the ORA agreement as a whole. You understand what I'm saying? You understand how this works. I'm just pointing it out to you because you should understand that basis. In addition, there is a concept called the statute of frauds. This dates back to 1666. You know you're part of a great profession when we have to teach you things that happened in 1666. But anyways, statute of frauds is the idea that certain things have to be in writing. What actually was happening was a whole bunch of people were getting a whole bunch of other people drunk at bars and basically saying, hey, I'd like to buy your farm. I'll buy you a beer for it. And they would shake on it and they would say, great, let's do it. And then suddenly the courts would find, well, that's it, you make these deals. The reason that the statute of frauds was put in place is because the only people who were actually literate, functionally literate, sufficient to actually understand legal contracts were your priest or your lawyer or someone who was learned. And by forcing this to be distilled to writing, what it was doing was providing for sober second thought at the time. That's the reason the statute of frauds was put in place, to avoid frauds. It turns out that the statute of frauds in all Commonwealth jurisdictions across the world continues to exist. And for the purposes of marriage, divorce, and real estate sales, not leases, sales, conveyance of land, it must be in writing. What does this mean? This means you can say to someone the words, unlike anything else. If you say to someone, I'll accept $30,000 for the car, and someone brings you $30,000, boom, that's a contract. But if you say, I'll accept this for the house, but it's not in writing and hasn't been agreed to by the parties, I'm sorry, there is no deal. Because statute of frauds mandates things must be in writing. Basic concept of how clauses and contracts work in the real estate sphere. Does that make sense? Yeah, it's not hard really, but yeah.
Sorry, can you read this, text a bit?
I would love to. I don't know how, without screwing with what they're seeing. So I'm sorry, but maybe someone can. If
I think that's just how Google Meets works.
unfortunately, I can't. But I will tell you what I will do. I've just sent over a copy of these slides, and I will send them around to anyone who asks as well. So you can just print out a copy as well and read this. So right now you can listen to the wonderful story that is my voice, and then you will have it and you can review it to your heart's content.
I think
Deb wants to say
Deb's
something.
eager to
She
talk.
doesn't. She's trying to take her hand down.
Oh, it's been
All
clicking
right.
the entire time.
Next, so we talked about, oh, I'm sorry, that's funny. That was the first thing I talked about, drafted versus standard clause. I'm sorry, that was the first thing I talked about. Contra preferendum, this is why we don't use Latin, I was getting mixed up. It's something else. It's the idea, I'm sorry, contra preferendum is a different concept. So the concept I told you about the first time is right. It's that drafted clauses always take precedence over the standard. Contra preferendum is a different concept. Contra preferendum is that where there is a dispute between the parties as to what a clause means, it is to be interpreted against the person who drafted it. Now, this, by the way, takes hold a lot in pre-con. Pre-con, where they give you this contract, and sometimes if they have something that is not defined or that doesn't specifically state what's going to happen, then the purchaser is in a really good state because they are not the people who drafted the contract. and thus the contract is interpreted by a court against the draftors. That's what contra preferendum is. Contra, against. That should have triggered. But again, I don't speak Latin in my office, so there you go. All right. Last, I wanted to just address, these are just basic concepts before we start going into clauses, but they all affect clauses. Last, I wanted to address the common law interpretation of signed agreements between parties. So it's often the case that people will sign secondary contracts between themselves at a later time. So I sign the agreement of purchase and sale on this day, and then I sign another contract on another day. Generally, the courts will look at the whole thing as a cohesive whole. It's all part of the same contract. But where there is a clause that contradicts a different clause signed later in time, then the courts will interpret that later clause as taking precedence over the earlier one, right? This matters. Like, I know that this all seems very esoteric in contract law 101 and law school and everything else, but this matters because if you think about it, this is the type of stuff you guys deal with all the time. And where it matters is not so much in this, but rather rather, if you think about it, let's say that you are in a sign back and you do not want to have to just correct a little error that someone makes. You want to solidify your deal, right? Knowing some of these concepts may allow you to just say, screw it. If it comes to court, I'm going to win this. Let's just solidify the deal, which often happens, right? Like, okay, there is two conflicting clauses, but I know that this clause was dated later, and I just want to firm up this deal because there's other people in the wings or whatever it is. Knowing this stuff directly plays into how it is you negotiate your contracts. And by the way, when you then call me, because you should be making these decisions on your own, you're going to call me and you're going to say, Mark, I can't sign this back. Because if I sign it back, when I sign back, it's not a counter offer, it is a new offer, right? Every time you sign back, I know we call them counter offers, but in law, every time you make a change, you haven't accepted unconditionally. And thus, when you are signing back, what you are doing is you are effectively recreating a new offer for them to accept. That's the reason you're changing their revocability. You don't want to do that if there's someone waiting in the wings to offer them more money, if you want to solidify your contract. So if you have something which you can sign and it has some form of discrepancy that we can figure out is acceptable based on the principles of contract law and clause law, which is what I'm calling it today, well, that really puts us in a good stead, and then we get our deal and we can worry about the fight knowing that we will likely win it. Does that make sense? That's the reason I'm kind of going over all this. All right, let's keep going. There is more to the law, general laws of contract and clauses that I want to address before we turn our attention to some specific clauses. And the most important one is one called good faith, which is for me hysterical, because when I was starting out my career, I was subleasing an office from a guy who was probably the most disreputable character I have ever met in business. Like, truly, I actually learned a lot from him. You learn a lot from the people who you admire, and you learn a lot from the people you don't admire. And he was just so, the way he conducted himself was so disreputable. And I kept on turning to my wife, and I was like, I cannot believe what he did today. Like, story after story after story after story. It turns out that like attracts like, and he was with a whole bunch of swarmy, dishonorable characters as well. And his father went ahead and got into bed with someone who was even more disreputable than him. And they got into a dispute over $70,000, which this guy being what he was, they took up to the Supreme Court of Canada. And his name is now enshrined as the reason to abide by good faith forevermore. So I now have to mention Bassin and Harnu as the seminal Supreme Court case for good faith, even though it is truly the name I least associate with good faith. But he set the standard. He set the standard for good faith. So what good faith is as follows. We often mistake what good faith is. We do not have an obligation to act in good faith, every one of us. In fact, you can act nefariously. You can act evilly. You can act immorally, not illegally. You can act all these ways. And you can act that way as an agent as well. You don't get me wrong, you have to abide by the code of ethics. But nothing I've said, by the way, You know, you being nefarious, being sneaky, you can be all those things and still be abiding by the code. Similarly, you can be all those things and you can be contracting with another party. There's no obligation to contract in good faith. None. What there is there's an obligation to abide by the contractual terms in good faith. This matters. In other words, do anything you want to get your contract. That's not where it applies. But once you have a contract, the terms, the parties have to abide by those terms in good faith. That's not what Batten and Harney said. That's what subsequent Supreme Court cases have refined the principle of good faith to. So where does this come into play? Well, this comes into play in the notion of conditions which you are actively waiting to be waived. So let's take our two most common conditions, home inspection and financing. So with a home inspection condition, if someone goes ahead and inspects a home and finds that a bathroom fan isn't working and says, thank you very much, I'm torpedoing the deal, does that sound like good faith to you? And then what happens if they say the bathroom fan isn't working and then the seller says, no problem, I'll abate the price by $250, I'll agree to fix it. And they say, sorry, still walking away. Does that sound like good faith to you? No. And objectively, it's pretty easy to tell with home inspection if someone is acting in good faith or bad faith. I mean, it isn't if you're dealing with a home from the 1960s that has aluminum wiring and got like, okay. But if we're talking about a Mattamy home that was built last year that, you know, is still under warranty, that, you know, looks pretty much brand new, and a home inspection comes and it fails and they try to walk away, well, that person is going to have to argue in trying to get back their deposits that they were acting in good faith, that they were fulfilling their contractual duties, and it was due to those contractual duties that they walked away. This is different than a financing clause, because a financing clause is by its nature much more subjective. Financing clause could be genuinely, I just plain am uncomfortable with where interest rates are going. I'm plain uncomfortable with taking on this debt, right? That's acceptable, right? Like you could say, look, I looked at it, I didn't realize what my monthlies were. That's a lot. That's something I'm not comfortable with. Now, it's true they may be lying, but good luck proving that. It's a much more subjective analysis, and the courts will give it much wider berth in their analysis of whether or not someone was acting in good faith using a financing clause. That's the reason financing is almost always an absolute out. And if someone comes to me and says, hey, they weren't acting in good faith, short of someone, if you have proof that they never went to a bank and they never investigated it at all, if you have a text where they say they're not even going to abide by this, they just want out on the basis of the clause or something like that, unless you have something like that, they're getting out on financing. Whereas good faith somewhat mandates that the other clauses are actually serious, and that the parties really cannot come to terms on. Does that make sense as a matter of principle?
So, sorry, then can I ask you about like if you include sole and absolute discretion?
Yeah.
Like, does that kind of give no?
Doesn't affect things actually. Strangely, sole and absolute discretion does not. Sole and absolute discretion is still the way that the courts have read it, is that sole and absolute discretion is not an absolute out. Sole and absolute discretion still mandates good faith.
Okay.
So, in other words, your sole and absolute discretion is that the fan is an issue. Okay, we accept it. But if they're ready to replace the fan, you cannot then rely on sole and absolute discretion, right? Like you have the overriding obligation.
So you still have to show that you went, you took strides to get that condition fulfilled. Like
Yes.
if you never called the home inspector and they try to get out.
Correct. You're crazy to do that.
Yeah.
You absolutely want to call the home inspector.
Yeah.
If someone says they're not going to call the home inspector, do not tell them what you know about law. Do not say, I'm aware that you say, okay, all right, thank you very much. And then you wait, and then the condition expires. And then you
And
say,
then you go after them.
you haven't called your home inspector. Because then they can't rectify it. If you say to them, you have an obligation to do this, they're going to just quickly call the home inspector and get it done and say, oh yeah, no, we found this.
Right.
And you have to be strategic as to how to do it. And particularly if someone is breaching, by the way, you should be using the advice of counsel. Not, by the way, because we're better negotiators. In fact, frankly, the residential real estate bar is actually not better negotiators than you. It's amazing how bad we are as a profession. Partially because, I'm not trying to knock my own, we have some very, very, very fine real estate lawyers that work in our profession. But it so happens that real estate law happens to be the place that people end up when they aren't successful in other careers, in law sometimes. And so you have a lot of people who are practicing real estate law, wills, probate, like basic consumer law, who really do not have much by way of functional negotiation skills or even understanding the law sometimes. So the reason you may ask, why is it that I'm saying that we should?
Is this the camera? Or that's the camera. That's the camera. That's the speaker.
So the reason you may be asking, why is it then that you should be listening to a lawyer, given that we negotiate for a living and you guys don't? Frankly, lawyers do if you just go to the right ones. The reason is because we have something that you don't. You guess what that is? What do we have that you guys don't?
A lot of
No. No, who cares about a law degree? No, it's not a law degree. We have insurance. So that when we tell you something, we're insured to tell you. So when you are navigating a breach situation, the reason you listen to a lawyer, hopefully you have a good lawyer that can actually help and navigate the situation. But also, when we say things and we say, listen, here's what it is. Here's how we're going to play this. Here's the way that the law is interpreted. You can rely on it. Because if we're wrong, okay, I have law pro that stands behind these statements in a way RICO doesn't stand behind you as you're trying to navigate a breach. Make sense? Simple? I mean, that should make some sense. Yeah.
I think it's worth also people knowing that when sometimes we have buyers who are really like, I want to put an offer in, we'll make a conditional on home inspection because we just need a little bit more time to decide what I want to do. I have actually been involved in the what was good faith situation, and I explained that piece to all my clients as well, because that did happen to me once, like a long time ago. I think we actually consulted with you at that time on the good faith.
Was that brilliant?
Yes, of course. This was Robert Wong, because I'd never heard of that before, right? So, but I think again, a lot of buyers think, yeah, they can just get it, so absolute discretion, we're on, and it doesn't.
No, it does not. Now, the next thing is interesting. I was just dealing with Dawn on this. Do you mind if I bring up the scenario? Okay, so Dawn just asked me a question. I mean, a rent was thrown in at the end of the court order, but let's pretend there was no court order. Dawn said, hey, there's a work order on the property that says no one shall be allowed to visit, just generalizing. And so my response to him was, hey, don't worry about that. Let's just get something that the city wants to sell this. They don't want the current owners who they have to put a work order on title for to maintain ownership of this property. They want nothing better than to put them the curb. I'll bet you anything, if you just ask them for permission to have visitors to the property for the purposes of selling, like prospective purchasers, then we should be good. Let's just get a notice from them that they agree. So even though there's a contractual thing there in the form of a work order that says you shall not do X, if we had gotten that from the city, which we're not going to because of the circumstances, but if we had gotten that from the city would be stopped from relying on their work order. Let me give you a better scenario. So I have a friend who runs a shampoo distribution system. He supplies all the salons in Ontario with their Moroccan oil crap that goes through people's hair. And this is a true story. And one day, he was like the exclusive distributor for this Moroccan oil thing when it was very hot. And one day he promised a pallet of things by contract to this very large salon group in Ontario. And they said, you have to deliver by the 17th. And that was what the contract said. He said, no problem. He called them up. He said, listen, we may have a delivery problem. It may be the 23rd. And they said, oh, hell no, 17th, that's what it says in the contract. And then they wrote them an email and they said, you know what, don't worry about it, the 23rd is fine, you can check with our managers, you're good. And he delivered it on the 22nd. He was then slapped with a lawsuit for breach of contract, because the contract says 17th. And we said, no. Yes, you have a contract signed between the parties that calls for this. But there's an equitable concept called estoppel. Your actions in permitting us to deliver this late now preclude you from being able to use that clause to our detriment. Does that make sense? Do you understand what estoppel is? That's the reason I was saying this. Let's get a letter from the city stating that they're okay with it, because then the city would be stopped from relying on their work order. That's the basics of, but again, you have court order, different, and so we're screwed. But that's the way estoppel works. So my point is that there's a whole lot of times that you may have a clause in an agreement where someone says, yeah, you have 3 visitation rights, but it's okay, you can do the 4th. Done. You cannot be held for breach of contract if they have said to you, yes, you can do this, and you are in relying on that, breaching the contract. They cannot then use a term of the contract against you. It's a concept called estoppel.
Even though it's not in the contract, but it's in writing.
Well, it doesn't even matter if it's in writing, if their conduct, but the reason you want it in writing is because how are you going to prove it? But if they say it, if they like said it during this session, they said, hey, Mark, like, and it was recorded, that would be fine. Like anything where there could be witnesses who can attest to it, whatever it is. My point is, a party's conduct can make it so that they are no longer able to rely on the terms of the contract. Make sense? Okay, do we have any questions from the audience there? You good?
Haven't seen anything come through.
Deb is okay. As long as Deb is okay. All right. 1 or 2 more things, and then we'll turn our attention to some specific clauses. So let's talk about the doctrine of merger. I think you guys all know this, but I'm just going to blab on about it for 1 second, just so that we're clear. Contracts exist only during the temporal period that they are active. What that means is a contract has a beginning, the date it's signed, and an end, the completion date. You guys all know this from real estate. At the completion date, the contract ceases to exist. And if it ceases to exist, so do all the terms and conditions of the contract. That is the reason that we write, the parties agree that this warranty shall survive and not merge on closing. What we're saying is this particular clause shall survive and not merge, which is the concept of all of the obligations and rights contained in the contract cease to have relevance at the closing time. So what we're saying is, even though the contract is now at an end, because we've completed and you've taken on possession and everything else, even though it's at an end, this clause shall survive and continue. Does that make sense? Does everyone understand that clause and why we write that? So as regards to chattels and fixtures, what we're saying is all chattels and fixtures shall be in good working order. By the way, good agents don't write all chattels and fixtures. Good agents should also combine, they should make their own clause at this point, where they combine chattels and fixtures if you want to really act for your buyer. All chattels, fixtures, and then there's this other clause that says all electrical, mechanical, everything else. I usually like to just combine all of them. All electrical, mechanical, plumbing, whatever it is, chattels and fixtures shall be in good working order. Why the hell not? See if they'll go for it if you're acting for the buyer. And if you're from the seller, look at them like they're crazy and say, no, we'll accept the chattels and fixtures. So, right? But anyways, the reason that we have shall not merge is because that way, when they take possession and they see that the stove isn't working, that's going to be after the completion of the contract. And if we don't have this clause in, then there's nothing to be sued on because you only had till the point of completion in order to have any legal rights under the contract. But we're saying, no, those legal rights extend beyond the contract, thank you very much, but they apply only to the state of affairs of the chattels and fixtures at the time of completion. In other words, if anything breaks after, that's not what it applies to. We maintain our rights to sue you for broken chattels and fixtures from the time you had ownership. Make sense? I mean, that's pretty basic. I think you guys all know it, but still. All right.
Excuse me.
Yes.
Until how long that we?
It goes forever, but good luck to you if you do not immediately report it to them within a day or two, because short of like a swimming pool that you're opening up in 6 months, because if you don't report it to them in a day or two, then they will say, thank you very much. It was in working order at the time we closed. It's now 3 weeks. It's clearly broken in that time. Right? So legally, you have until the end of time. Well, you don't have until the end of time. You have till the Limitation Act hits you, which is you have technically 2 years from the discovery of the breach up to a maximum of 15 years under the Limitations Act. But practically 1 day.
Tanya's got a question.
Yeah, Tanya.
Hey, Mark, I had a situation recently. I was on the listing side and during a buyer visit for a condo, I was told that the window cranks for the windows were not working and they used that chattels and fixtures clause to get my client to fix those. And, you know, it wasn't, my client was okay with it, but I never got a straight answer as to whether, you know, window cranks, are they part of that clause, right? So, and I spoke to our broker of record about this. She said there was a case once where she had to go through this and she had to actually replace the whole window because, you know, sometimes at that time, the crank wasn't just replaceable by itself.
Yeah, I'll give you your answer. They're not part of chattels and fixtures. And what's more, anything that they went through, even if they went through court, would have been small claims court, which is in guiding precedence. It just is not. There is the basics of real estate transaction is you're buying as is. Guys, it's good to think about a resale agreement like a resale car. If you buy a resale car and you see a car on a lot that has a giant thing of rust on it, when you get it, you can't say there's a giant thing of rust on this, I want it removed. You bought a car with rust. That's why you paid $5,000 less. And in this instance, you bought a house that has a window that doesn't open. It's not a chattel, it's not a fixture. We can go over what those are. It's not either of those things. So screw you. You're taking it as is. It is the car with rust. The reason you didn't technically pay me $250 more for this house is because this window latch was broken. We're not changing it. And a good lawyer should position that on you.
But if it wasn't visible, could they then, like if it was latent?
If it wasn't visible, although a window latch would be patently obvious, but if it wasn't visible and it was known to the seller and it wasn't disclosed, then it falls within the idea of latent defect, and thus, even though the contract has merged, you can revisit the terms of the contract accordingly. Yes. But good luck to you proving that.
Yeah, thank you. Thank you. I think, it's interesting because I think the lawyer that was representing my client was also like, oh, just get it fixed, right? That was their.
Right. And that, by the way, that's sometimes that's the right answer. Lawyers aren't there to just tell you what the law is. Sometimes we're there to problem solve. Like, if $250 is going to avoid litigation in the future or whatever it is, or just get the deal done, then freaking advise your clients to just do it, saying this is what the law is, this is the practicality, please pay the money so we can all go on with our lives. Because that's the job of a good lawyer. A job of a good lawyer is not to just think like what's the law, but to think resolution-based. Like this resolution-based law is the way your real estate lawyer should be thinking about real estate. Because the lawyers that only think about law from the perspective of law are the people you want to stay away from with a 10-foot pole. Not 10-foot pole, 5-foot pole. 10-foot pole are the people who don't know law in the first place. 5-foot pole are the people who only know the law. The lawyers you want are the people who actually understand that law is nuanced by reality and practicality.
Okay.
Right?
Well, thank you. Thanks for that. I think, could you maybe help us understand what chattels and fixtures are so in a property so we can differentiate that? Just for, in this case, it was just, $500-$600, not a big deal. But
Oh yeah, I can, except that I made a promise to myself many, many, many years ago when I started talking to brokerages that the only subject I would never, ever address with anyone is what is a chattel and what is a fixture. Just because it is so obvious in Google. And like, it's not to say that there's always an obvious thing. Like there's always the 300-pound garden gnome. Is that movable? Is it not? Whatever it is. But just because there's no nuance to it, just look it up on Google. And I just, as a matter of course, in maintaining my own legal dignity, I'm gonna blow through that question. I hope you don't mind.
yeah, no, that's okay. That's okay. Yeah, thanks.
It's not that it's not a good question. I'm sorry, Tanya. It's just, it honestly is something I've said to myself over the years.
Mark, so I guess we should be writing as the listing agent in the schedule for the buyer to be accepting the property in an as is or as viewed state.
Yeah, well, I mean, if you can get the property is as is.
I mean, as is sort of suggests that it's a fixer upper, like if we put that in the listing, but even just like a clause saying that the buyer accepts the property in an as viewed state.
Right. Well, it doesn't matter what you put in the listing.
Right.
It doesn't matter. Like that's just advertising.
Yeah.
Remember MLS? What's MLS? MLS is just advertising. That's all it is. It has to be compliant with the Competition Act, but it's not the agreement that's agreed to by the parties. So yes, you need to have the schedule be an as is.
Yeah.
And then of course, if they write
as is mean, can you say as viewed?
Yeah,
like as the buyer viewed it. Like the window crank was broken.
But as is better.
Okay.
Because as is a legal term that has been defined by case law.
Okay.
Whereas as viewed can be argued because it isn't actually as refined.
Okay.
Just FYI.
Yeah.
Okay. Tanya, I hope I wasn't being dismissive. I wasn't meaning to be. So please.
No, thank you. I think it's just something that we'll always have questions about, right?
No problem. So I want to talk to you now about the Consumer Protection Act and unconscionable transactions. Just very quickly. First off, the Consumer Protection Act does not apply to real estate deals. It does not apply. It's specifically exempt from an agreement of purchase and sale. So nothing I'm going to say has anything to do with the clauses that you use for an agreement of purchase and sale. but it does directly affect your listing agreements and your buyer agency agreements, which are your contract for services. And if you add any clause in there that is unconscionable or that is unfair practice, then we can cancel it on the basis of the Consumer Protection Act. Example, let's think of the example that always happens. Don't worry, just sign these documents. It's only for this buy only. You then get sign a buyer representation with someone and find out that they unknowingly, as part of their offer with this guy with trying to multiple, signed a BRA that lasts 6 months and goes for all of Toronto. Well, when that happens, I've had a couple of calls from this brokerage where that's happened, where they're like, look, this guy didn't even know that he signed this BRA. It was part of the flurry of paperwork that was done through Authentisign when he was trying to bring an offer for this guy's home listing, and now he's locked in for 6 months. Well, then they get a nice letter from me. It's a precedent letter, so it makes me look really good because I'm able to produce it really, really quickly. It looks really like that. Put a lot of work into the file. This is important for building purposes, by the way. But when you're not, KW. And you say, thank you very much. Be advised that this contract is null and void. You engaged in an unfair practice. You promised us, as a matter of course, that this was only for this transaction. And yet you wrote us in, you told us something. You said that your services had a quality that they definitively did not, which is an end date of that night. Therefore, under the Consumer Protection Act, I'm now canceling your buyer representation agreement. Sue me. Come at me. Because when you sue me for having purchased another property, my defense is going to be that this contract was void under the Consumer Protection Act and had no valid validity in the first place. Or I can get a court order affirming that. That's what the power of the Consumer Protection Act is. Or if you charge Granny, as actually happened to someone who came to my office, 9% commission because she didn't know better for a condo in downtown Toronto. Or if you act unconscionably in that way, if you hold juniors, if you steal someone's dog and you say, I'm not giving it back until you sign my listing agreement, that's unconscionable, right? All these things are unfair practices or unconscionable, and if you use them in the context of soliciting services for yourself, being buyer representation agreements or listing agreements, then you may fall foul of the Consumer Protection Act. Though remember, these do not apply to an agreement of purchase and sale. Different laws apply for that. This is not part of an agreement of purchase and sale. Make sense? Okay, let's get to some last thing before we turn to specific clauses. And now I'm going to turn to drafting. This is the biggest mistake agents make. Every single one of you, please take notes. Because honest to God, when someone asks me to draft a clause, this is all that differentiates my clauses from yours. I am thinking of a singular question, which is, have I addressed all outcomes? Let me give you an example. Buyer and seller acknowledge that this property is subject to probate. Everyone understand what probate is, right? Like, okay. Should a certificate of estate trustee, that's what probate is called, not be obtained by the closing date, the parties agree that this agreement shall be extended by a further 6 months. Okay, so we did told what happens if that happens. The seller agrees to provide the buyer with 15 days notice in writing for such an extension. I get that all the time, that type of clause. Always. It's a terrible clause. That's a terrible clause. You guys should be embarrassed for drafting that clause. Why should you be embarrassed? Well, because you have left dangling principles. Think about this. Okay, I extend. And what happens if it's contentious? And what happens if it goes beyond that 6 months? Someone tell me what happens if it goes beyond that 6 months extension. I have no idea. Do you? No, because you didn't address it. All you did was address what happens if it doesn't happen here, but you didn't put, it's a dangling participle, right? You didn't address what happens. So, the buyer and seller acknowledge the property is subject to probate. Should a certificate of estate trustee not be obtained by the closing date, the parties agree that this agreement shall be extended for a further 6 months. Same thing. The seller agrees to provide the buyer with 15 days notice in writing of the need for such extension. Same thing. Should probate not be obtained within time or extended time set out above, the buyer shall, at sole and sole option discretion, shall be permitted to further extend the closing date for a further 6 months. Or elect to terminate the agreement, in which case the agreement shall be null and void and the deposit shall be returned in full without deduction. That's still not good enough though, right? Because what happens if they elect to extend and it still hasn't happened? Well, should the probate still not be obtained by the end of the buyer initiated extension, this agreement shall be null and void and the deposit shall be returned in full without deduction. Now you have a complete clause. This is the essence of good drafting. This is the difference between a good clause and a bad clause. You should be thinking through like a logic statement, if then. And you know how in Excel, if you use the if then statement and it says error, not good. You need to have all aspects addressed. If then, closed off statement with enough parentheses at the end to make it a complete and final statement. Does that all make sense for those of you who understand some logic? All right. So clauses have to have consequence. All right. Let's turn to specific clauses. And let's just address Tressa. Yay, Tressa. First off, I'm just going to point out to you that any specific clause you now draft where you're trying to inform someone of a disclosure at the property now needs to say the word disclosure. This really sucks for me because one of the things I like doing as a lawyer is writing really nice emails where I was actually saying things like, hey, how are the kids? That's fantastic, blah, 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 blah. And then halfway through in the meaty middle, say, and you know what? It's great that you know about the electrical. Yeah, it's probably something you're going to have to fix up. And by the way, Sunita Campus Wonderland on Tuesday or everything else. And in doing that, I could show the court previously that they had knowledge of what it was. I had disclosed it. But Tressa, getting wise to people like me, probably rightly, has now said, no, you're not allowed to play tricks like that. Now, when you disclose, you must say the word disclosure. And as a result, I am expecting on our agreements, we should get into the habit of having something that literally looks like this. Disclosure. Seller hereby discloses to the buyer that the attic may contain asbestos material. Okay? That is compliant with Tressa. It must say the word disclosure in big block letters like this. And that includes as part of the agreement of purchase and sale or prior to the agreement of purchase and sale. So you don't need to make the disclosure as part of the agreement of purchase and sale. But if you are making a disclosure as part of the agreement of purchase and sale, make sure it's Tressa compliant. Okay? All right. Let's talk about a clause I hate, and I've asked you guys not to use, but I'm going to do it because I keep on hearing about revival clauses everywhere now. It seems to be the new thing for agents, where they want to all say something that other people don't know about. So they all talk about revival clauses. What a revival clause is thank you very much. An agreement of purchase and sale has a condition and the condition goes dead. Right? So the condition says in the event that the home inspection hasn't been waived by this time, then the agreement is null and void and the deposit shall be returned. And so someone has come up with the idea and said, don't worry, we can just have a revival clause. And so they write this thing that says the parties hereby agree that the agreement has been revived. They sign that as an amendment. Okay, or they do, the parties agree notwithstanding the fact that the conditions contained in the agreement of purchase and sale, say this is an amendment, dated March 31st have expired, the parties hereby agree that the then agreement shall be revived and all rights and obligations contained thereunder shall be of full force and effect. So that sounds even more legal, but it's still really bad. It still doesn't make sense. And this is the reason I'm going to ask you guys, if you guys are going to use revival clauses, to make sure you use a lawyer. So let's consider what's happened with a revival. A revival is, so what is the state of the contract at the time you're doing a revival? Dead. It's over. It is finished. So what is the only thing that can bring about a revived contract? A new contract, right? A new contract. And what does a contract need in order to be a contract? Needs consideration, doesn't it? Exactly. Now, if you write that first sentence, where's the consideration?
Some
In the previous contract, which
It's
is
in
now
the
dead.
previous contract that is dead. There's no new consideration for this. I mean, technically there could be. If you have a good argument, you can say, well, yes, both sides are getting a benefit. One side is actually now able to close. One side is able to get title. So there is that consideration, but it could be challengeable by the courts. In fact, I think it would be, and I think it might even be successful. That's the reason that a proper revival agreement done by a lawyer would read as follows. Whereas the buyer and seller previously entered into an agreement, and whereas the buyer and seller's agreement was subject to a condition which expired, and whereas the buyer and seller are desirous of reviving the agreement, now therefore for $2 and other valid good and consideration herein acknowledged and received, the parties hereby agree that blah, 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 blah. In other words, A new contract with fresh consideration would be brought to bear, such that if this went to court, it wouldn't even be a consideration. And my point is this: revival clauses where you're dealing with a deal that has already gone dead are dangerous, and you should be getting advice from a lawyer. There is a reason that certain legal language is there. Do not think that revival clauses are one of your arsenals. It's great that you know about them, but please, please, please just run them by a lawyer before you use them, if you ever need to use them.
Deb raised her hand, but I'll ask for her because she texted me. She just said she wanted to clarify when it's used. It seems for like the APS where the conditions weren't fulfilled. Is that
That's typically what it's used. It's typically used when an agreement goes dead and someone says, "Don't worry, we can just put in place a revival clause." At which point you have to say, "Okay, I know what that is," and you say, "Aha, I'm going to run it by my lawyer." That's all I'm saying for you to do. Okay, just before you accept those things, don't negotiate those.
I don't know. She thought it was more.
Yeah, go to the question.
Is that enough?
Okay, Deb
I don't know.
Deb says it. Deb
I read it verbatim, so I don't know.
All right, all right. Okay,
Oh, she
so
left.
let's keep on going for more specific.
I have a
laws.
question, Mark.
Yeah.
That $2, is it for the consideration, would that be considered like a deposit?
No, it's just for the contract.
Does it-
And you don't need to pay it because it's here and acknowledged and received. So it's understood that the $2 doesn't need to transfer. It's just acknowledged that it has been paid. And it's not a deposit, it's not accounted for. or anything
Because a
else.
deposit is not consideration either, isn't it?
No, the deposit is not consideration. The consideration of a real estate deal is what? Not a deposit.
Signing under seal.
No, it's not even that. Everyone thinks it is. So everyone says, well, and that's correct insofar as because it's signed under seal, you don't need consideration. But there is consideration. Let's say that we had an agreement that was not signed under seal and that had no deposit. Would it be valid? Yes, it would.
Oh.
Because what's the essence of your contract? Essence of your contract is the promise in the future to transfer title, or the promise in the future to transfer money. That's the consideration, right? There is valid consideration. The reason we sign under seal is because there is a period in the offer process where there is not an agreement between the parties, namely the irrevocability period, where one person needs to be bound to not withdrawing the contract. And as a result, we sign under seal to give effect to that irrevocability clause before the parties have agreed. That's the reason we sign under seal. The reason we get a deposit is because otherwise they disappear into the then night. This has nothing to do with law. The actual consideration of an agreement, and I say that, by the way, everyone believes it's the seal. To some degree it is, because it does act as consideration too. But the real consideration of the deal is the promise to pay for the promise to transfer title. That's what it is. Right? Actually, technically, it's not a promise to transfer. It's a promise to transfer ownership. There's nothing in the agreement that calls for the transfer. It's strange. Okay, I'm going to mumble to myself a bit more later on. Let's just keep going. All right. So we have vendor take back mortgage. Well, I was going to say more and more. You see this, but the market is now on fire. So we're now done with the vendor take back mortgage period of like 4 months. But basically, be all and end all is this. The vendor take back mortgage that they have on web forums is totally deficient. It's totally deficient because it looks like the above. It basically says you're going to agree to a vendor take back mortgage of X dollars for this amount for this period of time. It's great. Those are big considerations. You know what the biggest consideration is when you have a mortgage? How much security do I actually have? And if you're buying a property if you're selling a property for $1 million and you're agreeing to take back $200,000 of that as a vendor take back mortgage, but the other person has borrowed $900,000 to TD Bank, then your $200,000 is $100,000 short in security. Make sense? Maybe even more after commission. Big problem. So a vendor take back mortgage needs to address how much, if it has a first position or not, and if it doesn't have a first position, how much equity there needs to be in the property prior to placing this mortgage. Right? Critical. In other words, the seller shall ensure that the mortgage is placed in title and priority to this one do not exceed 60% LTV of the property sale price. Okay, so I know that you're going to get a first mortgage to TD for 60%. I know that I'm giving you a mortgage back for 20%, but that leaves an extra 20% in equity, which is my security. Make sense? That's why VTB needs to be structured properly. Another reason why, if you're doing a VTB, you may want to bring it to a lawyer too. Okay, what next clause did I come up with? Assignment clauses. These are just random clauses that are, I think, always hit my office. So there's two different things in the assignment. I'm almost out of time, but there's two different things in the assignments world that most people, there's a million clauses that you need as part of assignments. And if you don't know how to do assignments fluently and conversely, then either do one of two things. One, if you get an assignment agreement, bring it to your lawyer before you bring it to your client so that you can look all intelligent and present to your client and say, I think we need to have these changes. That's the best way forward because it makes you look really good in front of your client and then they understand why they're paying you the big bucks. Or alternatively, get a lawyer review so that the lawyer can do the review and then say, listen, we have to make these changes and that's it, right? But, and there's a whole bunch of clauses that are part of an assignment, but the biggest ones that you guys should be thinking about as part of Schedule A is, of course, when we're paid, not how much you're paid. You can negotiate that on Schedule B, when those payments take place. Under a standard assignment agreement, the payments are as follows. There's a deposit that's paid. Then there's the return of the deposit that was originally paid to the seller, which is usually paid at the time of acceptance of the builder of the assignment. And then there's the balance that's due and owing, which is paid on final closing. In fact, if you do nothing to the normal Form 145 or 150, that is the way the payments work. People change it, particularly if you're dealing in, as an example, markup. If you're dealing with the Chinese community, it's largely cash-based. There's a cultural tendency there to pay cash for assignments up front. And so they often put a lot of risk on the assignees because what they do is they say, all right, we're going to take in this $20,000 deposit upon acceptance. And when the builder gives consent, we are going to go ahead and pay the full amount, all the profits to you. So that's why you should accept our offer. This is hugely dangerous because if the builder goes bust or if the builder cancels the project or anything else, the profits minus the deposits that are still being held in trust by the brokerage are not something you can recover from except from the assignor who's now away in Iran or wherever it is, right? And I have this written down. My point is there are ways of writing these clauses, and the way you really want to opt is the safe way, which is option one, which basically has a deposit that's held in trust by the brokerage, and then you return the deposits that have been paid to the initial seller, so to the builder. So let me just quickly go into that. It's often, for those of you who don't regularly deal with assignments, it is the case that most people believe that when you bring an assignee to the table, they think that the builder is going to give back the deposits to the original purchaser and then take the deposits from the second purchaser. That's not what happens. What happens instead is that the builder says, yeah, we agree, and then they ascribe the credit for the deposits they already have to the new buyer. So the new buyer, therefore, has this advantage of a credit and has to pay back that credit plus the profits to the assignor. And so those are the monies that have to be assembled in the process of an assignment. And it's usually paid by a deposit upon acceptance. Then the original amount that has gone back to the seller, that was paid originally to the seller, goes back to the assignee for immediate use. Why? Because the assignee now has a direct credit to that amount. And then the balance, the profit minus the deposit that has been paid, is paid on final closing. That's option A, and usually you want to write it in. You also want to write in when your commissions are paid. People who deal in the assignment world often don't want to wait 3 years for their commissions to be paid, and thus you can put in optional clauses which allow for the immediate release of commissions, which will then instruct the brokerage to so release those monies. And I do whole courses on assignments, so I'm not going to go into it. And if any of you are interested, it's all on our websites, and I've done a whole bunch of talks about this in some detail. So don't be that confused. I'm just pointing it out to you because we're dealing with clauses. And now I'm going to subtly leave my phone number up there for reasons that only great marketers will really grasp. And ask if anyone has any questions.
Just on that last thing, the assignment.
Oh, not on my number?
I know your number. I can't, I gotta put my, I feel like Bono because I didn't bring my glasses. ABC Builder, they've got this pot full of money. That money never leaves that pot. All the other money comes from the new assignee and all that.
Correct. That's exactly right. And that's what causes so much confusion because there's a natural tendency to think, okay, well, we're switching, therefore they're going to put me back into my state, and then that person will then pay all the deposits like I did. But that's not what happens. Yeah. They don't get involved in that at all. They just credit
Have you ever had an instance, when you talked about the financial, clause, conditional clause, where this sole and absolute discretion of the buyer made it toward or got a little bit far?
I've been doing this for 25 years, so the answer is yes to most of your questions at this point, and yes to that question in particular.
Right, and
It's settled.
Yeah.
They agreed to move forward.
okay.
But they agreed to move forward actually because the property values were going up so fast that by that point, they actually one day they swooped around and said, wow, this is a really good deal.
Right.
Let's just proceed. But we did have to file a statement.
What's the difference between the agents get around mergers for contracts and the revival clause?
So the agents, the merger and getting around merger doesn't require a revival. What we're saying is the original contract continues to exist for the purposes of that. Whereas a revival is saying the contract is dead. We're going to bring back the contract into life.
Oh,
Does that make sense?
yeah.
Do you have any suggestions or recommendations for dealing with the property that's tenanted when it's being sold, either as listing side or
I do.
that you're
I
sellers or buyers?
So look, our province of Ontario is broken. It's very sad. But like we are totally broken when it comes to landlord tenants. It is just a terrible state of affairs. You need, as a listing agent, to draft a clause that has a consequence. This is the critical component. You need to basically say, here it is. We agree that we shall provide notice to vacate, the L2, the N12, and everything else. You need to put all that in. But dangling participle, if you do not address what happens if they refuse to leave, and you say, should the tenants, having received such notice, refuse to leave, then, and you can make, you can define it. You can say, then the buyer shall agree to assume the tenants and take a reduction in the purchase price of $50,000. Then the buyer shall be allowed out of the agreement, whatever it is. Just do not leave it as the seller shall provide this notice and vacant possession under section 2 remains. Because you may have a seller who simply can't abide by their contractual rights. So the critical components to dealing with Ontario's shocking, and abhorrent lack of responsibility in maintaining the landlord-tenant board is to make complete statements. It's the only thing we have, because lawyers can't help you and paralegals can't help you. The reason we have a landlord-tenant board and the reason we have a small claims court system to offer justice is so that we do not take baseball bats to one another's faces and we have a mechanism of resolving disputes as adults. But if it breaks, then frustration builds until people come out baseball bats, and we're really at a broken state. So to avoid that, make sure you dictate exactly what will happen, given that you know that this is potential services, and talk about exactly what happens if they don't leave, and make sure everyone's on page with that before you sign the agreement for tenant property.
If you're representing the buyer and on closing, the tenant hasn't left,
And you can just go crazy.
what does that mean?
You're in breach of this contract. We're putting a certificate of pending litigation on your property. We are going to, we will demand that that you remove this, or we'll agree to take this on, but we want the courts to order that we'll be fully compensated for the cost of said removal. And there's any number of different options that can come to bear, but you can encumber the property, you can do, it's a breach.
Right,
It's a
right.
breach.
Because the price is going up so much. So, my buyer buys a property 3 months ago and now it's worth a lot more. They don't want out of the deal. They still want the property, but they also don't want.
Lawyers should be able to advise and help with it. So what you do is you basically say, let's come to an agreement as to what we're going to do. And if the other side is unreasonable, say, okay, then we're just going to proceed to close. You're going to breach, and then I'm going to put a caution on your title, and we're going to sue you for the difference. We'll get a court to award it. Either you're going to agree to it, or of course going to agree to it, because we didn't have a complete term that defined what would happen. Yeah.
Oh, I was just gonna say, typically when I write a clause, this is right. Who is to do it? What is to be done? When is it to be done? Who is to pay for it? And what happens if it doesn't happen?
So that's it. It's exactly right. And if it doesn't happen, what is the consequence? And whatever you're going to draft is the answer to that. It needs to be a complete and rounded answer. There can be no variation that ultimately leads to now, well, what now? Exactly. And that's the solution, by the way, to landlord tenant board. It's the only solution we have right now. Anything else? Good. Well, I'd like to say it's been a pleasure. Yeah, sorry.
We were in a clap.
All right, well. It's been a pleasure, and I'm very happy to actually be meeting everyone in person. So thank you.
Oh, my God. CC